The parties are two energy companies, Oil States Energy Services, LLC, and Greene's Energy Group, LLC. The petitioner in the case, Oil States Energy Services, is a company that makes fracking equipment. Oil States sued Greene's for infringing two of Oil States' patents. Greene's then asked the Patent Trial and Appeal Board to review whether the patents were properly issued and whether the patents were valid. The PTAB said the patents were unpatentable. Oil States versus Greene's raises two interesting issues. The first issue is Article 3 separation of powers. And Article 3 guarantees that for matters dealing with property, for matters dealing with private rights, you need a judiciary that's independent and accountable to no one but the rule of law. Because the PTAB is a creation of Congress, it's an animal of the executive branch, PTAB judges are selected by the director of the Patent Office, who's a political appointee, and the composition of panels at the PTAB can be adjusted to promote or to put the thumb on the scale. So it raises a host of interesting Article 3 separation of powers issues. What must only be done in a federal court? What can an administrative agency do? The second related issue that it raises is the question of whether a patent is a public right or private property. If a patent is a public right, like a taxi cab medallion or like some other business license that's given by the government, then it's perfectly reasonable for an administrative agency to have its own body that reviews and potentially revokes issued patents. Because a patent does not exist but for the United States Patent and Trademark Office, the Patent Trademark Office has the right to revoke what is issued. If a patent is found to be private property, you cannot have the Patent Trial and Appeal Board deciding whether a patent is invalid, because if something's private property, the answer will likely be that only an Article 3 court can take that property. Greene's argument is that a patent is a public right. Article 1, Section 8 of the Constitution provides that Congress may pass laws that are intended to promote innovation, to promote the useful arts. But it's not a right that must exist. It's something Congress may do. And the way Congress implemented Article 1, Section 8 was through passing the Patent Act, which empowered the United States Patent and Trademark Office to review and grant patents. The way Oil States has presented this issue is as one of the separation of powers. There's a reason why there are three separate and independent branches of government. The judiciary exists so disputes over property can be adjudicated in an impartial and unbiased manner. Oil States argues that patents are private property rights. Because a patent is a private property right, disputes can only occur in a federal court and must be heard by a jury. Although these patents deal with fracking technology, the implications of this case will span wide sectors of the economy, from pharmaceuticals to software to automotive components to medical devices to anything that is protected by a patent. And with the administrative state growing in power and importance, it's a timely question for the Supreme Court to consider.